All right. So I'm sitting here with my litigation paralegal, Yannick, and we're going to talk about what not to do during a depo.
Yeah.
You know what? This shouldn't be funny, but this is actually a real thing. One of the things that you should not do, you should not get coached by somebody behind a camera during Zoom. Because currently the whole thing with the Zoom is that people, they can't see, they only see the face. If the person asks you the questions, if they can notice you're speaking to someone behind the camera, they find out, they can ask for attorney fees and stuff like that. They can cancel the deposition. That's one thing. And Yannick is actually going to chime in on what happens on our side once you get a notice from them saying that you were getting coached by somebody or you were getting notes from somebody. You can't write notes. It has to be your testimony. Number two, if somebody says you cannot do something, like literally cannot do something, it better be something you literally cannot do. Because if you can do it and they catch you, they're going to say, well, you said you couldn't do it, now you can, so you're lying. So if you can do it, but you can do it with pain, you say that. You do it with pain, with restrictions. Because lying is the big thing. And Yannick, if you want to talk about like what happens when people are lying during the deposition, what happens when they send us, like, because the opposing counsel, the attorney on the other side, will send us a request and they'll ask for production. So if you want to talk a little about.
So if they feel like they're catching you in a lie, what they'll do is they'll send a supplemental request for production and they'll ask for further documentation or in other cases, they'll maybe subpoena a medical provider from the past regarding, other injuries you might have had or other medical issues that you've had. So it's better just to be honest up front because that will keep them from digging up, other things that we might be able to pretty much hide by just answering truthfully at the outset.
It's a great point you brought up. Honesty is the best thing. And I know that's kind of cliche, but honesty truly is the best thing. The insurance company, they have a large reach. They can find out information forever. Like they know information before we know information, and not because we can't get it, but they're tied to other insurances databases. So they know if you had other claims. They know if you got hurt. They know all these things, and they will request all those medical records. So if you lie during a deposition, they're going to find out in some way. So don't think you're trying to be sneaky and you don't want to tell them. There's things that we can object to, but if it's relevant to the case, they can get it. So it's better to be upfront even with us because we have this thing called attorney-client privilege. We need to know as the law firm all the issues. That way we can figure out what's the best way to attack this for it can lessen or mitigate the damages. Because what happens, it goes to your credibility in the court. Imagine being in front of a jury and they say they lied about this, they lied about this, they lied about this, they lied about that. Who cares about your injuries? You're a liar. So now they think you're faking these injuries.
Yeah, if you're lying during the pretrial stuff, that's going to encourage the defense to take it. That's going to encourage them more to take it to trial because then they'll be able to show a jury or a judge that you're in fact dishonest. So then they're going to question, your injuries at the outset during the trial.
Also, if you're in a deposition and they say, do you want to add anything else after the grueling process of deposition? Never add nothing else. Never say last minute, oh, by the way, I want to add blank, blank, blank. And the reason why, because without saying names, that happened to me in one of the depositions, and that person decided to add, it looked like they slowed down and stopped in front of me. So now liability changed. So the value of the case went from here to there because our client decided to add extra facts into it. So it's already grueling enough going through a deposition. You want to keep your answer short and concise. You only want to answer the question that they actually asked. Because when they ramble, the more information they get from you. Mm-hmm. And as Yannick said, the more information they get for you, they'll do requests for production, submissions. So what have you seen on your side? Whenever, let's say they're talking stuff, if they're talking about things that they happen during deposition, what do you get on your stuff? Like you mentioned something like request for production and stuff like that.
Yeah, so we had an instance where, similar to what Mr. Reyes was talking about, someone was not that they were being coached behind the camera, but they were looking at something. They kept putting their head down, looking at something, and it turned out that they had some sort of notepad. So the other attorney wanted to see this notepad, and then they asked for the person to produce the notepad. So we had to have our client come up here so that we could make copies of this stuff and turn it over to the opposing side.
And that again goes back to credibility, because even though you weren't attempting to do nothing wrong, it doesn't look good. If it walks like a duck, it talks like a duck, it may be a duck. And that's a story that they're going to try to tell, even though that may not be the true story. Remember, it's whatever the story that can be sold. And the more you're giving to them a story, the more it's going to be, it's like when you get, it's like a criminal thing. Everything you say can and will be used against you. The thing is that you have to say what happened in the accident. A deposition, you can't, unlike criminal, you can't withhold information. You have to talk about it. There's certain objections that I can make, but they're more on form if the question is confusing. Not everything you say will come out in jury, because we can probably block that through a motion in limine, which is like reducing the evidence. But if you don't bring it up, or if they ask you and you don't answer, they can stop it. They can have a judge come in immediately and make you answer. So, you know, these are things that what not to do during a deposition. And, you know, we'll still walk you through this process. We'll still sit down with you before any deposition. Yannick will actually send you the interrogatories, which those are questions that you filled out about what happened in the accident. And if you want, Yannick, what are interrogatories? That way they know it's...
So interrogatories are once the defendant receives the complaint in the mail or by service of process, they have a time to respond to that complaint. Usually when they respond, they'll submit interrogatories and an initial request for production. The interrogatories are questions written and directed at the plaintiff themselves. So a lot of the information we'll have on file already through the intake process, but some of that stuff is a little more specific to the present situation with the plaintiff. So we'll probably call usually and have those questions answered by you directly. So you're aware that these interrogatories are being written up, and we're responding to them, and we submit those back to the defense that's their side of the evidence gathering. And so at that point, when the deposition comes up, we want to return those interrogatories to you for you to review, because they're going to ask you similar questions to the interrogatories. They might even say, in your interrogatories, you said this, and then they'll ask a follow-up question based on your response to the interrogatory. They might ask you to elaborate or expound on what you've already said.
Yeah, interrogatories is a big thing, because they really do follow the interrogatories. That plus we'll send you a medical summary showing of all the medical doctors you've seen, just to help refresh your memory. It's completely okay if they ask you a question that you don't know the answer. Let's say a doctor you may not know the answer, say, I don't know. But you have to make the best efforts to answer that question, because they're going to try to trip you up. So you want to have a good idea of the doctors you've seen, the questions that you wrote an interrogatory that you gave us, and we're giving you a copy as well. The other thing was the way it works in deposition, the flow of a deposition, every flow of deposition. They ask a lot of questions that mean nothing, because they go off billable hours. They ask you about your background, they ask you about your family, they ask you about all these different random things. They're trying to establish a foundation. But they always cover your previous injuries, always. It's past, present, and future. So they always cover your previous injuries. That doesn't help you. The reason why they're doing that, but that doesn't necessarily can help you, is because they want to know, did you have another car accident or another accident or something that you injured yourself because of previous, and has this previous affected your current condition? And they can say, well, that's not our fault, that's your fault from before, and not covered.
Yep.
And then we have present. How did this accident affect your life, and how is it affecting your life currently? And so that's where all the medical visits, you know, if you had any pain and suffering, all these different things that happened during all the visits you had to go to, if you had surgeries, all that stuff, that's your present. And the biggest part of the claim is the future. So if you have no more pain, then the future claim goes away. If you don't have a permanent injury, a permanency, saying that you have this issue from now to the future, that means your future damages go away. And that's future's pain and suffering. If it's affected your life, if you can't, play with your kids anymore, you can't do the activities you used to love doing, lost income, stuff like that. And these are all things that we need to report of. So every deposition follows the same thing: past, present, and future. So when you think about answering questions, you want to answer the question they asked, but the past is you want to mitigate, answer the question, just don't offer more information. The present, how the accident happened and, what you had to go through. In the future, that's where you want to elaborate more of like how this affected you and your life and your family and your loved ones. So that's pretty much the flow of a deposition. Of course, we're going to be here for you. This is a video just to kind of like preempt you to understand the idea of the deposition, because it can go long. I mean, you've seen,
Depositions can last they can be as short as an hour, or they can last for, 3 hours. And a lot of that will have to do with the way that you're responding to the questions. If you are offering more information, you're giving them ammunition for certain follow-up questions. So like you said, be concise with your answer. Don't offer more than they're asking, and kind of let the opposing counsel guide the questioning. You don't want to give them questions to ask you, basically.
Yeah, the more you talk, the more they'll ask. It's like, it really is like when you get pulled over by law enforcement. The more you talk, the more they'll ask. So you want to keep it concise. Never offer more. Never say I have something else to add after the fact, and be honest. And from that, everything should be okay. So thank you. Like I said, if you have any questions, of course, feel free to give us a call. And we'll be more than happy to help you. We're going to help you through the process anyways, but this is something you need to know before going into a deposition. The idea is keep calm. I know it's a stressful situation, and just know it's a conversation. If it gets too crazy, the conversation, we can always object. We can always move it for that they're embarrassing you, they're harassing you, whatever the case is. So just stay calm, stay focused, and be honest.